Rise. Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within and for the Commonwealth. Draw near, give attendance, and you shall be heard. Now see the Commonwealth of Massachusetts, court is open, please be seated.
Good morning and welcome to the Appeals Court. I am Justice Meade. With me today are Justices Ditkoff and Toone. Will be the panel for all the cases today. Each side gets 15 minutes. You needn't use all of your time. We do not entertain rebuttal. We have read everything. My best advice is to get right to the point. With that, I'll call our first case, 24P1319, TRESCA Brothers Sand and Gravel versus Eames Street, LLC. Mr. Is it Sooney or Sonny?
Sooney.
Sooney. Thank you.
Thank you, Your Honor. Good morning. David Sooney for TRESCA Brothers Sand and Gravel appellant. I'd like to address two topics to sort of emphasize the importance of the reversal of the Superior Court's decision. The first topic is that after 10 years of permitting, with opposition from Attorney Lipkin and Benevento, which is a concrete competitor of TRESCA, TRESCA's South Shore, Benevento's North Shore. TRESCA was successful when it came before this court and won its right to permit a concrete plant at the leased premises that are at issue in this case. The question of the supremacy of recorded plans that were approved after opposition relative to a subsequent lease dispute about whether the lease permitted TRESCA to permit as it did is an interesting question, but one that I think has to be resolved in favor of TRESCA. Again, multiple Superior Court litigations happened.
Sorry, are you saying that a permit overrules who owns the land?
Yes, the permit runs with the land.
No, overrules. So if I got a permit to build something on Judge Meade's land, then I would just get to do that?
Yes, because in this case, the predecessor in interest to Benevento was the owner of the land, Lehigh, and very importantly, Benevento purchased the property with full knowledge of the permitting process. So I think it's somewhat the bona fide purchaser doctrine, if you will. But I think it's an essential thing for the court to consider to take a private party dispute and to allow the parties to rewrite their agreement or interpret it differently would turn 10 years of permitting efforts on its head.
Well, the judge said that's what he wasn't rewriting the lease. He said that's what the lease says. The lease limits the property in which the concrete plant can be built to what's specified in Exhibit A.
Yes.
And you're saying, no, the permitting process somehow changed the scope of what's allowable under the definition of leased premises, right? Is that
correct?
So just tell me.
Right. So there's two aspects to it. There's the bigger question of what is the supremacy of the recorded plan. But then there's the secondary question, which is perhaps more directly relevant to the court. We have de novo review of what a contract means, right? And in the contract, it specifically says that the leased premises, and this is page 47 of the appendix, and this is probably the only page, frankly, that the court really needs to look at. We considered making a motion affirmatively in our favor for summary judgment, but it wouldn't have completely disposed of the case, so we didn't do it. But if you look at page 47 of the appendix, you'll see that the leased premises are defined by both what is referred to as Exhibit A in paragraph 102A, but also paragraph B, which is all improvements thereon. But most importantly, the leased premises also include subparagraph C, all licenses, permits, and other agreements are pertinent thereto. In that regard, it's important to note that Lehigh, the predecessor in interest to Benevento, and TRESCA entered into a joint venture so that Lehigh had half the property, TRESCA had the other half. Lehigh was a cement supplier to TRESCA. TRESCA was a concrete manufacturer, so you need to get the cement from the supplier, and then you mix it with water, sand, and gravel, and you create concrete. So they had a joint venture. Both of those parties to this lease that's at issue in this case, proceeded to embark on this 10 to 15-year permitting process. It's important because, A, it helps define what paragraph C means when it references licenses and permits. TRESCA got the licenses and permits that the parties intended it to get, and also that the licenses and permits that Lehigh signed off on and agreed to.
Right, but 102C says a pertinent to, right? And the judge says that means with a leasehold, what's in existence at the time the lease is executed.
Right.
So you're saying, well, flash forward 17 years and we got this, the town finally gives us the permit, and now that changes the meaning of what lease premises means under the lease, but that doesn't seem to be consistent with the rule of what pertinent rights means in this context.
Sure. I mean, I think in this case, it was the party's intent that it would be existing or future pertinent rights. And in particular, if you're going to, there was no existing concrete plant there. It's not like the parties knew where the batch plant was going to go. They didn't know where the egress was going to be or ingress. So the parties then permitted the concrete plant, and portions of what got approved were outside of this sketch plan A, undoubtedly. But the best example of what the parties intended is the conduct that they engage in after the execution of any contract.
Why did TRESCA agree to the lease to begin with in 2003 if it intended to construct a concrete plant that went beyand the defined boundaries
Sure.
in Exhibit A? I don't get that. Like, it
Sure,
seems like
sure.
it seems instantly there was an agreement, and then the entire process, years go by, we're going to build something beyond those.
Yes. It was a conceptual plan. Rent did not start until the permits were approved. So the parties had a joint venture. Lehigh was going to sell cement to TRESCA. TRESCA was going to buy the cement and permit the concrete plant. TRESCA invested more than $1 million based on the representations of Lehigh, the landlord, and the permitting process. And most importantly, no one would ever permit the plant first unless if it didn't have the property under lease. You have to secure the right to permit the plant, right? You don't know in advance where's the groundwater retention pond going to go, where's the parking going to go. That's all dictated by the town of Wilmington and the permitting process.
Well, why not renegotiate the lease once you know that the plant that you want to build is going to go beyond what's set forth in Exhibit A? That's why I don't understand.
Understand. So our view is that the lease was in fact modified by the parties' conduct, as well as the signed writings and permit applications. Lehigh signed off on permit applications to the town of Wilmington.
So, counsel, you said that the signed permit applications are in the summary judgment record. Could you tell me where in the appendix I'll find that?
I'll have to look for that. I don't have that off the top of my head, but.
Okay, because I couldn't find it, so if you can't tell me where it is, I'm going to have to assume it's not in there.
Yeah. I think perhaps I can come back to that, but it is undisputed that there was 10 years of permitting history and the plans were signed off on. I think the court could also take judicial notice of the permits. The permits wouldn't have been issued if they weren't signed off on. I think the important point is that what happens next is that Benevento, who has opposed this permitting effort because it doesn't want TRESCA competing with it on the North Shore, then engages in a straw man purchase of the property from Lehigh through a different entity, an entity owned by Martinetti from Martinetti, the son of Martinetti Liquors, who flips the property unknowns to Tresca to Benevento. So it's an anti-competitive act. But in the course of that closing, perhaps shrewdly, perhaps in violation of Chapter 93A, Benevento gets Lehigh to sign a document that says the lease premises are just in sketch plan A. Sure, we'll pay you the $2.8 million for the property, but you better tell us that 15 years of permitting history doesn't matter. You've got to tell us that the lease premises are what's in sketch plan A. And they agreed to do that. Well, frankly, that's not dispositive. There's a factual issue, a big, serious factual issue about the credibility of their director of real estate's later testimony when he
You're
comes
talking
in.
about the 30B6 deposition testimony where he says there was no amendment of the lease, right?
Correct.
Is there evidence in the record regarding the supposed agreement that sort of says you'll testify this way if we give you by this lease?
It's not an
that's your
obvious.
theory.
It's not an obvious quid pro quo. They wouldn't admit that at the deposition, but these were representatives of Lehigh who signed off on these plans, who engaged with Tresca. It just, to be clear, the town of Wilmington would not have approved any permits. No town will ever approve any permits unless the landowner has signed off on them. It's just required.
What happens, say, what happens now, say that the judge's decision remains in place? What happens with the lease is still in effect? There's just nothing happens. Essentially,
right.
Your competitor kind of bought out your lease, and
yes.
Therefore the project is dead. They paid the money, but then
yes.
there's no possibility of doing a new concrete plant that's confined to the geographic limits set forth in Exhibit A.
Right, because we tried to work with Benevento to say, okay, what's going to go where? They had no interest in having the concrete plant be there. It sort of becomes a dead property.
But if you can build the plant on the leased property, they're going to have to sign the permit application, right?
If we tried to permit it within the parameters of Sketch Plan A, they would have to, but the town has already spent a decade permitting and directing where different aspects of the facility will go, including a groundwater retention pond, including parking, in places other than within the Sketch Plan A.
And therefore?
And therefore, the lease was essentially amended, and/or Benevento is stopped from asserting this argument. I mean, on the permitting side of it, the town of Wilmington appealed, did not want to approve the original special permit. TRESCA appealed. This court upheld the special permit. The case got remanded to the Superior Court after the Supreme Judicial Court denied review and ordered Wilmington to issue the permit. They issued the permit, and then Benevento appealed the issuance of the permit somehow, making the contractual argument. And this court said, you can't do that. You can't appeal it. It's valid. So we have this odd situation where this court on 2 different occasions has validated TRESCA's right to use the property in accordance with the plans that were permitted by the predecessor in interest.
But just in theory, you still have the option going forward to try to come up with a new permit, a new plan that's confined to the geographic limitations in Exhibit A and get that permitted and move forward, right? You still have those rights under the lease.
If it's permittable, but I don't know if it is, because TRESCA went through the permitting process. So in theory, that's possible, but in reality, it would be difficult to do, and I wouldn't want to put the town through another 10 years of litigation. So I think that just to go back to this for a second, how the parties conduct themselves after the execution of a contract is a critical, undisputed factual issue or question or undisputed fact, how the parties conduct themselves. And here, the landlord to the lease authorized everything that TRESCA did, and the permits were approved. So it can only be, to read this contract the way TRESCA intends to read it, is really the only rational interpretation of the contract, particularly in light of the fact that Benevento's predecessor, Lehigh, interpreted the contract this way.
Thank you.
Thank you.
Mr. Lipkin.
May it please the Court, my name is Alan Lipkind. I represent the appellee Eames Street LLC and all of the non-municipal defendants. With me this morning is my colleague, Nick Allen. And I'm here on behalf of my clients to ask this Court to uphold the decisions of the Superior Court on summary judgment, on the Court's ruling on the motion to dismiss, which primarily eliminated TRESCA's tort claims, the ruling on the reconsideration of the motion to dismiss, the denial of the motion to amend, the ruling on the reconsideration of the motion to amend, which was upheld by the single justice. The first issue I'd like to address, and I'll just touch on it briefly, is that the lease is not ambiguous. The lease defines the lease premises in section 1.02 of the lease. The lease was between TRESCA and Lehigh Falls Cement Company. It defines the lease premises by reference to an attached plan. That attached plan breaks the property in two. It's kind of tough to figure out, but if you look at page 223 of volume 2 of the record appendix, you can see an existing conditions plan done by one of TRESCA's engineers at some point, and you'll see that the property is really comprised of two assessors parcels, parcel 3A and 3B.
So on that document that you had us, that document you're talking about right now, like there's little like circles and stuff and like a square with circles in it that's outside the area. What is that?
Okay, so you're referring to the lease plan, not the plan at RA.
No, the thing you're just talking about, with the colors. Lease area overlay plan.
Yeah, that wasn't the one at RA 223, but what that plan shows, I don't need to look in the appendix, because if you could just hold it up for one more second, Justice Ditkoff. Yeah, that plan shows the lease area, the area that's set forth on the lease plan, laid over what I would call the permit plans, what TRESCA got permitted on the site.
So that
it's
stuff
showing,
is those little things I'm seeing is what's supposed to be built under the permit.
yes, going from my memory, what the effort was to try to show the things that TRESCA needs to build to comply with the special permit that are outside of the lease.
Right, okay, I get it.
Okay.
And is it your understanding, could TRESCA go ahead and build a concrete plan within the bounds set forth in Exhibit A? Is that possible?
I don't know. They would have to go apply for a permit to do that. They haven't done that. I can tell you that within the record appendix is my client's plans for this site that don't use any part of that, what's shown to be the area leased to TRESCA for its purposes. It wants to use the property to as a place where it can have a rail siding, offload other construction materials. There's a ban on it having cement at the site, but TRESCA is free to use the lease premises as defined on the lease plan to set up a concrete plant. And just picking up on.
Well, can I just ask, how long is the lease extend in perpetuity, or how long does the lease go for?
I think there was an initial term of 10 years going from memory with an option to renew for another 10. But the lease term didn't start until they get their permits and start operating.
So what does that mean? So like has the term started? Or
No.
No, because they have not received a permit within the confines, so
Right.
then what happens?
Well, the lease
This
has started,
exists
but the
forever?
term hasn't started.
Huh?
I didn't mean to
The
cut you.
term of the lease, yes. When is the term of the lease going to start?
When they're permitted, and I think when they start operations, something like that. But it doesn't last forever because there's a termination provision in the lease that says, you know, when they get to the end of their efforts to permit the plant and they can't do it anymore, they're not pursuing it expeditiously, landlord can terminate. So
after this, if the decision's affirmed, after this, they either have to go back and make an effort to get a permitting within the confines of Exhibit A, or if they don't make that effort, then eventually your side can claim that the lease is terminated.
we can pursue our termination rights. There's probably some notice provision, but yes, I didn't read that to prepare for today, but that's how the contract works. They need to pursue their permitting, and if they don't, or there's a final ruling that they can't permit it, then the landlord can terminate.
So let me ask you, just getting to the heart of TRESCA's argument, I think their strongest position is that we can consider the party's subsequent conduct to, including extrinsic evidence, to kind of determine what the lease means. And there certainly was this extensive effort of, evidence of Lehigh working at least hand in hand with the permitting requests. Why can't we look at that to sort of figure out what the parties really intended here?
You can look at that, but I think that misstates the record evidence as to saying that there was cooperation. There was.
I know it's not in the record, but they did sign the permit applications, correct?
They signed, there was some evidence that they signed some permit applications, but the evidence cited was an affidavit of Lehigh's counsel opposing, seeking to quash a subpoena that TRESCA served on them. And what he said was that, and what the evidence showed was, yes, some Lehigh representatives signed some applications, but no plans were attached to them at the time they were signed. And Lehigh saw this as just supporting its tenant, and Lehigh's understanding was that if they ended up getting a permit that required them to go outside the lease premises, they would have to come back and get a formal lease amendment, just as the 30B6 witness testified. I think that the Superior Court got it exactly right on this point. They were aware of this, and they said there just wasn't enough to say that the lease was amended. This kind of dovetails into the whole joint venture idea that just came up on the appeal, was certainly never part of the record before the trial court. I'm surprised was brought up in the briefing here today. I don't think that's appropriate for argument, but if TRESCA thinks it had some joint venture with Lehigh, that has no bearing on my client. My client bought real estate with a lease that had a defined lease plan and with a representation and warranty from Lehigh that said, here's the lease, it hasn't been amended. And there is absolutely no record in the evidence that my client somehow forced Lehigh to do that. Lehigh was trying to sell this property they decommissioned this plant, this cement plant where cement would come in by rail, tractor trailers would come in on that loop road that was on the pavement that wasn't part of the lease premises. They decommissioned it in 2016 or 17 when they bought another facility out in Palmer, Massachusetts. They were marketing the property to others, not to my client. So to say that Lehigh...
Why did your client acquire the lease?
I'm sorry, what?
Why did your client want to acquire this lease?
My client wanted to acquire this because my client, the Benevento people, is an integrated construction materials organization. They sell gravel, they sell asphalt, and there's a ban on having cement on the portion of the premises that's not leased to TRESCA, but they wanted this so they could bring in construction materials by rail into Wilmington, perhaps, and the plans are there, store it in the portion of the site that's not leased to TRESCA and use it in their other facilities. They have an asphalt operation in Wilmington. They have an asphalt operation up someplace in New Hampshire, I'm drawing a blank on the town, but to have a site with a rail siding where you could bring in rock, gravel, they could use that as part of their integrated construction materials. I'm sure I'm not using the right words, but the things that go into buildings, you could bring them in by rail, not cement, offload them there and use them, the non-leased portion of the site, for their business. That's why they wanted to do it.
So was shutting down a competitor like a happy incidental effect of buying this property, or was that part of the? I mean, it does seem like there's anti-competitive flavor to what happened here.
Well, there's no evidence of that other than my brother's suggestion, but there's absolutely no evidence. There's plenty, you can't make that argument without putting in some sort of analysis of what the marketplace for concrete sales is in north of Boston. There's plenty of concrete companies. Keeping TRESCA out of it would have no impact at all to my client, and there's no evidence on that. That's just throwing mud at the wall at the appeals court, hoping something will stick. My client wanted to acquire this property because it was a site with a rail siding. It could bring in asphalt, rock, whatever it is, for its other businesses. There's plenty of other sites that TRESCA could go to if it wanted to, and my client would have nothing to say about it. And they could also operate here within the confines of the lease, and my client would have nothing to say about it. My client there's a design in the record where TRESCA can stay on its lease portion of the site, operate there, and operate a concrete business. That's not what this case is about, and there's certainly no evidence of unfair competition. It's not in the complaint of record, and the motion to amend the complaint was properly denied. Now,
the motion to amend was denied primarily for undue delay, right? Not for futility.
No, I don't agree with that. That's how my brother characterized it in his brief. The motion to amend, especially if you look at Judge Buxton's decision on the motion for reconsideration, she goes into explicitly that it was futile. And the flaws with regard to interference, those still remain. The flaws for abuse of process are self-evident. And the same thing for the new claims that were going to be in there. The judge said they had the flavor of futility or something like that. And we addressed it in our opposition to the motion to amend, and I thought we hit it pretty squarely, and that the trial court got it right. So I think that the trial court was 100% correct. Yes, we all grow up being lawyers saying leave to amend shall be freely granted, but sometimes if an amendment is futile, it shouldn't, and sometimes it's too late. Here you had both of them. And I think the court was rightly upset that it identified in 4 separate rulings the flaws in the interference and conspiracy claims, and they were never fixed. So if TRESCA wanted to protect itself, Judge Toone, what it should have done is when it saw that it could not get a concrete plant permitted, if that's the case, within the confines of the lease premises, it should have sought an amendment of the lease, especially when it knew the property was going to be sold. And that's in the record that Lehigh, some salesman from Lehigh came and told TRESCA was going to be sold. They didn't bite on that. At the Superior Court appeal of the zoning permits, they said they were going to buy the property. When they saw that property was going to be sold and they needed to be outside the lease premises, that was the time to seek an amendment. They didn't do it. So I think that the lease is not ambiguous. It's plain. TRESCA is supposed to fence the portion that was leased to it. It wasn't allowed to interfere with the landlord's use of the remaining premises, and the court was correct in its rulings on the motion.
I have a technical question. The 2021 Middlesex appeal, I saw there was a notice of appeal and the appeal was assembled, but that's been dropped, right?
I'm sorry, what was
So
this?
there was after the permits issued,
Yes.
there was a 2021 Middlesex Superior Court case by your clients to challenge those permits. And the judge ruled against it, and there was a notice of appeal. Appeal was assembled, but I didn't see anything beyond that.
We filed whatever was necessary to dismiss the appeal.
So the appeal's gone.
Yeah.
Okay,
It was-
that's all. I just want to make sure there wasn't an appeal out there that I couldn't find.
No, it was dismissed. It was dismissed. We didn't appeal it. You know, we might have filed a notice of appeal, but then we
That
dropped
happens all the time. I just wanted to make sure I wasn't missing an appeal.
No, you're not missing anything, Justice Ditkoff. So, again, I see my time is almost up. I'd ask you to affirm the decisions of the Superior Court. If you have any questions, I'm happy to take them at this time. Otherwise, on behalf of my clients, I thank each of you for your attention this morning.
Seeing none, thank you. Thank you both. We'll take it under advisement.
Thank you.
Our next case is 24P 1201, James Jones versus Town of Barnstable Conservation Commission. Mr. Silverstein.
Good morning, and may it please the court. My name is Jonathan Silverstein. I am here for the plaintiffs' appellants in this case, who are appealing an entry of judgment on a motion for judgment on the pleadings, affirming a decision by the Conservation Commission of Barnstable to issue an order of conditions for after-the-fact clearing work and then construction of a number of improvements within buffer zone and wetland resource areas on their property. There are two primary arguments asserted by the plaintiffs in this case. One is that the Superior Court erred in refusing to allow supplementation of the administrative record as filed by the Barnstable Conservation Commission. And the second is that, based upon the record, the Barnstable Conservation Commission was arbitrary and capricious in issuing its order of conditions and not considering certain impacts and regulatory violations proposed by the application. Beginning with the Superior Court's refusal to issue or to allow supplementation of the record, there are two parts to that. One is with respect to regulations of the Conservation Commission itself, and the other is with respect to a determination by the Department of Environmental Protection regarding the existence of coastal bank that will be altered by the proposal of the applicant. With respect to the Conservation Commission's regulations, I would submit that—
I don't get why those need to be in the administrative record at all. I mean, a court can just take judicial notice of them, right?
There is case law, Your Honor, that at least in the context of zoning bylaws, courts may not take administrative notice of those, and I would concede that most likely the same rule would apply to the Conservation Commission's regulations. But that being said, how is it possible to review a determination or a decision of a local board without considering the board's own regulations? And I would submit that—
The motion judge said that supplementing the cases you rely on to supplement the record, none of them are certiorari actions, though. I mean, you even couched your answer to Justice Ditkoff with in zoning cases. But in certiorari cases, supplementing the record after the fact is not permitted.
Well, it can be permitted, Your Honor, but I guess my answer to Justice Ditkoff was just in acknowledging that I'm not arguing that the local regulations were subject to judicial notice. What I would say is it is facially implausible to suggest that the Commission's own regulations had to be submitted during the administrative proceedings for them to be before the Commission.
Let's look at it differently. Now, your brother says that there was no evidence submitted before the Commission that any of these additional resources were apparent on the property that would call into play these two regulations that weren't considered.
So I would say that's a different question, Your Honor. So
Well, let's try to answer it, though.
Fair
So
enough.
if there's nothing in the record that implicates the operation of these two regulations, what difference does it make?
So I would say there's plenty in the record, and we've cited to it, and the counsel who represented the plaintiffs before the Superior Court cited to it in the complaint and argued based upon it. There's plenty of evidence in the record. What I will concede is
the
that
commission relied on Mr. O'Day's testimony instead, and not Mr. Tennyson, who I think conceded that these resources weren't there.
I don't think he conceded they weren't there. I think he conceded that I think he focused his argument based upon different resource areas. And what I would say is a certiorari review is limited to the record before the commission, but we're not limited to arguing what was argued before the commission. It's not like appellate review where you waive the ability to make an argument if it wasn't raised below. Here, my clients were pro se before the commission, and I'll concede they did not make the argument based upon Coastal Bank before the commission. But the evidence we're relying on was before the commission. And so the question
what is that evidence of Coastal Bank that was before the commission?
the topographical evidence, the plans, our arguments that this comprised Coastal Bank, and again, I'm putting aside for the moment the DEP determination, which
So which plan would tell me this is a Coastal Bank?
I argue it in the facts, Your Honor, based upon the definition of Coastal Bank and the amount of area that was cleared and the elevations of the area that was cleared. It's all set forth in the statement of facts. Where we haven't tried to submit any evidence, any new plans, any new testimony, any affidavits. All we're trying to do is point to the evidence that was before the commission, the plans and the application, and state that based upon the regulations of the commission itself, which I would submit are always part of the commission's purview and record. No one ever goes into the commission and says, I would like you to admit.
I'm looking at the plan on page 56. How do I know it's a Coastal Bank? It says flood zone.
Yep. So if you look at page 197,
Well, 197 is the,
that's the definition.
yeah, of other things. Coastal Bank's
And-
195.
And then if you look at page 56, the insurance firm map, the FEMA firm map indicates that the depth of the area is that will flood satisfies that definition.
I'm sorry, where it says FEMA zone, that tells me what the slope is?
So the argument, and this is set forth on pages 9 to 10 of our statement of facts in the brief, we cite to the evidence in the record that we're relying upon to satisfy the definition of Coastal Bank. The problem is, we're not contesting a determination either by the commission or by the Superior Court that we're wrong in this regard. We're contesting the inability to make that argument based upon evidence that was in the record because we were not allowed to cite to the commission's own regulations.
But did the plaintiff cite or refer to or mention the regulations before the commission?
No, Your Honor.
Okay.
Again, they were pro se, and we're not trying to.
Well, how would the commission know that these are in play? I mean, I understand they're pro se, and we want to be generous with them.
Fair enough.
You have to know like what the challenge is, and if you're not even referring to the regulations in the proceeding, I'm not sure any agency can really assess that issue.
I understand that, Your Honor, and it's not uncommon when an issue is raised that the commission didn't address or any local body didn't address to remand it to address an issue that's supported in the record if it wasn't addressed during the administrative proceedings. Again, my argument is there is no requirement, and I've been appearing before local boards for 30 years. I have never gone into a local board and said, here's a copy of your regulations. Will you please put this in the administrative record? It's never necessary. It's always before them. They're charged with administering the regulations.
What are the restrictions, if it is a coastal bank, what are the restrictions on a coastal bank? Because I didn't see anything in 705 that said there's things you can't and can't do to a coastal bank.
So we also raised issues, Your Honor, with respect to other resource areas, but with respect to coastal bank, the requirement is to address the impacts and determine if there is mitigation that's going to be required.
Where do I find that? I mean, I looked at because I can take judicial notice too. I looked at the regulations and I didn't see anything that told me what you can and can't do with a coastal bank in the town.
A coastal bank is a resource area, and so I would cite to you Volume 2, page 42 to 45, which prohibits alteration of any buffer between a resource area, such as a coastal bank, for 50 feet. And
It's the one that has to be within 100 feet of the project? Does this regulation come into play because when it's within 100 feet?
well, there's a 100-foot buffer zone between any resource area and proposed work, but
If it's outside the 100 feet, then it doesn't come into play.
Well, it wouldn't be a buffer zone. That's correct, Your Honor. But
And the judge found the project was more than 500 feet away from the nearest wetland.
but a wetland, he found that it was 500 feet from, I believe, the nearest pond. But the Wetlands Protection Act and the board's local regulations regulate more than just that type of resource area. It regulates coastal bank as a resource area. It regulates vernal pools. It regulates isolated vegetated wetlands subject to flooding. And what I said.
Was there any evidence of vernal pools?
There is, Your Honor, and I do cite to it. But going back to Justice Ditkoff's question about what the regulation would be from the coastal bank, the coastal bank is within 50 feet of the project. And as I cite to, there's a requirement to request a waiver if there's going to be any disturbance within 50 feet of any resource area. No waiver was requested or granted. And so that's one example of the significance of the fact that there's a coastal bank. My brother cites to a decade-old determination in a different filing, a different application, in which DEP says this is the only type of resource area we're looking at.
Is that when the house was built?
Yes, Your Honor. Yeah. But ignores the fact that wetland delineations are only good for 3 years, and DEP has affirmatively found that this project is going to disturb coastal bank.
Let me ask you this. There's a pending appeal to DEP that's been stayed pending our decision.
Yes, sir.
What effect is our decision going to have one way or the other on that appeal, from your perspective?
Well, DEP generally stays its proceedings until litigation related to local bylaws is resolved, because local bylaws are allowed to be more stringent, but not more permissive. Here, the local bylaw and regulations are significantly more stringent, and so the DEP generally takes the view that we're not going to look at our lower standard of review until there's resolution on the higher standard of review under the local bylaw.
If we affirm the judgment, DEP is not foreclosed from investigating?
It is not, Your Honor, but we're foreclosed from arguing under the local bylaw and regulations, which is what the Superior Court's determination not to allow reliance on the Commission's own regulations has forced us to do.
Can the DEP in its review consider those regulations?
No, Your Honor. Can only consider the State Act and the DEP regulations.
Okay. Thank you.
Thank you.
Mr. Schultz.
Good morning, Justices of the Appeals Court. For the record, Attorney Michael Schultz on behalf of Washington SGG Nominee Trust. I would submit to the Court that the Superior Court did not abuse its discretion in denying plaintiff's motion to supplement the record because none of the proposed materials were presented to or considered by the Commission when it issued its order. A motion to supplement the administrative record is to the discretion of the Court. Under Standing Order 1-96, a complete record of the proceedings before the Commission was filed by the Town of Barnstable. It included what was only before the Commission, which was Chapter 237. It did not include Chapter 704. It did not include 705, coastal banks.
So why weren't those before the Commission?
Because there was absolutely no evidence submitted to the Commission. There were no issues with anything other than what my brother admitted in his brief, which was on page 7 of his brief, stormwater flowage.
I mean, isn't that a little circular? Sure, if there's no evidence of any problems that 704 or 705 bring up, then you win, regardless of whether that's part of the administrative record or not. But if there is evidence that implicates 704 or 705, wasn't it before the Commission, the regulations before the Commission?
But there wasn't anything before the Commission on 704 or 705. There was nothing on coastal banks, and there was nothing on vernal pools, vegetated wetlands, unvegetated wetlands. The Commission made its determination based on their level of knowledge and based on what the engineer, John O'Day, submitted. The only resource was land subject to coastal storm flowage. If that's the only resource, Chapter 704 specifically exempts. If the only resource, then 704 is completely out of the picture. Similar to denying the request for Chapter 704, they didn't make any claim whatsoever to coastal banks. The plan that was before them, what they're trying to do months later, is based on DEP's former counsel, Attorney Watsky. In his complaint, he made allegations of coastal banks. This site was looked at back in 2016. It went through a thorough and an in-depth review with the Commission and with DEP. One of the present plaintiffs, Elizabeth Sullivan, she was a party to it. On these two lots where what we're looking to do is to build a pool house, and a cabana.
Does the 2016 study have a shelf life?
It may have a shelf life. I don't know whether I agree with my brother in that regard, but what they did allow was the construction of 2 homes, 2 pools, decks. They allowed the filling of the depression. There was no allegation before DEP at that time of coastal banks. The plaintiff at that time hired Lenore White, who was the expert at that time. She put forth evidence of purported vernal pools, vegetated wetlands, and after that thorough and in-depth review with DEP, the only resource that was applicable on that property was land subject to coastal storm
Is
flowage.
this in the record? The
sorry?
stuff you're just saying about 2016, is that in the administrative record?
It was referenced, Your Honor. It was referenced, it was brought up by John O'Day and by the commission. It referenced the SE3 numbers, SE3 5059 and SE3 5960.
So doesn't that mean the administrative record is missing all this 2016 paperwork that you're referring to? If that was part of the administrative proceeding, why isn't it part of our administrative, why am I seeing in the administrative record this White study and all these determinations that you're telling me about?
Because plaintiff's expert at that time, his name, plaintiffs weren't pro se, they were represented by Garrett Toone. He was the expert that was hired to represent them before the commission. He put forth all of their concerns representing the abutters in the neighborhood. Mr. Toone only referenced, and he acknowledged that the commission didn't have any jurisdiction to vegetated wetlands or any vegetation, but he referred to, interestingly, to Lenore White. And he used, before the commission, he referenced her in her work in 2016, that she had done a lot of work, but what he didn't disclose to the commission was that her work was rejected by DEP and by the commission, and none of the resources were found to exist at the property.
So is the White report before us or not?
It's a part of the administrative record, and
Where is it in the administrative record? I didn't see it.
You mean it was referred to?
it was referred to, Your Honor, yes.
All right, so if someone mentions Lenore White, does that make her record, her report or the 2016 proceedings part of the administrative record?
I would suggest that it would, Your Honor, yes.
Okay, so don't we need all that stuff then?
That's all.
If that's all part of the administrative, if the Lenore White report is now part of the administrative record because she was mentioned, then don't we need to see the Lenore White report?
I think that it's contained within in the record itself.
Okay, where?
I don't have the reference offhand, but I do recall inserting both the SE3, the decisions, the plans, those components that Lenore White had made at that time, Justice Ditkoff.
Your brother says the August 23 DEP letter was a determination of additional evidence of additional resources. What's your answer to that?
I would disagree, Justice Meade. I would suggest in what is put forth by Maison Rita, who's the chief, when she wrote back, she said it's merely the opportunity to present and to analyze. So what we're looking at is we're looking at a property that's set back more than 2 blocks away from Nantucket Sound. I think we can walk around the city of Boston and find slopes of pavement of certain areas that are greater than 10%. And would that be deemed to be a coastal bank? On its face, maybe you say that it's a coastal bank. But you have to have a resource that's identified with the allegation that you're more than a 10% slope. Nantucket Sound is more than 2 blocks away, more than 500 feet. Crystal Lake is more than 3 blocks away and probably 500 feet as well. That's what the reference was in the material.
So the letter is an indication that they were going to look into it?
That's correct, Justice Meade.
And is there have they done that, or is that what the pending appeal is about?
It's still in process. What we're going back and forth, we had experts looking at water flow, and a very strong indication is that there is no coastal bank. We're not located anywhere near a resource. And that was the finding that DEP made in 2016 after its thorough analysis was the only resource is land subject to coastal storm flowage. There are no buffer zones. There are no performance standards. There is nothing that applies to this site.
So what happens if DEP says this is a coastal bank and it complies with the state rules, but there's an argument that it doesn't comply with the town rules? What happens then?
So if you could repeat that, Justice Ditkoff.
So let's say DEP looks into it and says, this is a coastal bank, but it's okay under the state rules, state performance standards. And let's just assume there's an argument that the more stringent town standards would have a problem with it. What happens at that point?
I'm not sure. So
And they go back to the commission and say, you've got to reconsider, or is it just over?
I think that they might go back to the commission to reconsider.
Okay.
But just going back to, and I'll wrap up on the administrative record, that's solely within the discretion of the court. The court denied that motion. The materials were never before the court. With respect to affirming the order of conditions, I would respectfully suggest that it was supported by substantial evidence, was not arbitrary and capricious, and was not an abuse of discretion on any other portion of the law and should be upheld. The decision was in accordance with the regulations. In its memorandum of decision, the Superior Court had a very legally sound and a well-reasoned decision. It reviewed the purposes and interests of the Town of Barnstable's Wetland Ordinance, Chapter 237. It set forth the burden on the applicant. The court did not accept the appellant's claim that the proposed work would affect any other resources other than coastal storm flowage, and the Commission's failure to consider to make findings were not part of the administrative record, and they were not persuaded by the case law. With the statutory groundwork that was laid, the court reviewed the notice of intent in accordance with the local regulations, and among other things, that the NOI identified the description of the work as accessory to a single-family dwelling, which was under development and outside of the jurisdiction of the Commission. The NOI provided that the only resource was land subject to coastal storm flowage. It was not located within a velocity A or a coastal flood zone A. It was exempt from the stormwater management guidelines because it involved the construction of a single-family home. And there were no erosional concerns to wetlands because the site was over 500 feet away from the nearest wetland resource. The proposed site plan that was prepared did propose drainage elements to address the concerns of the abutter. The order was based on substantial evidence in the administrative record. At the November 1st, 2022 hearing, John O'Day, the appellee's engineer, provided a history of the parcels. He walked through again the history in 2016. The Commission agreed specifically with Mr. O'Day in their expertise and knowledge of the area to confirm that the only resource was land subject to coastal storm flowage. The Commission discussed that there were changes to the grading and to the fill. They went through and agreed that if the project were approved, that he would provide a revised plan adjusting the elevations and the grading. Mr. O'Day did do that. A revised site plan was submitted on November 22nd of 2022. During that hearing, Mr. Toone, he spoke on behalf of the plaintiffs and the appellants, and the only resource, again, in which was admitted to by my brother, the only resources that he discussed before the Commission were storm flowage, storm water, and the water table. That was it. Neither Mr. Toone nor his clients provided any credible evidence of any other wetland resource. In fact, the plaintiffs, they concede, again, of that. The order was further, it was conditioned to address the concerns.
What exactly did Tennyson concede? What was his concession?
He conceded that the only, that it was storm flowage, coastal storm water, and the water table that was before the Commission, that the Commission had no jurisdiction over any vegetation. Because he identified, through his expertise, he knew what Lenore White had testified to and had presented to in 2016 before the Commission. The order was addressed, or conditioned to address the concerns. Among other things, they considered drainage elements on the applicant's plan. The work would conform with the revised site plan, and they would include dry wells, leaching basins, and to revegetate any disturbed areas. And based on the foregoing, I would submit that there was substantial evidence before the commission, and the decision was not arbitrary and capricious. I would also respectfully suggest that Washington SGG should be awarded its attorney's fees, that they, in connection with this appeal, at no point in the administrative record did the plaintiffs or the appellees provide any credible evidence of any resource other than those that were presented directly to the commission or through the representative, Garrett Toone, and they were the only resources: storm flowage, storm water, and the water table. Washington SGG submits that purporting to rely on the resources from 2016 by Lenore White, but not adhere to that binding decision at that time, and knowing full well that the only resource, what was applicable at that site, and failed to appeal that determination, is a needless consumption of judicial resources. And based on the foregoing, would respectfully request that this court affirm the Superior Court. Thank you.
Thank you. Thank you both. We'll take it under advisement. The next case is 25P262 ADA Management Services versus Ho and another. Mr. Aaron.
Good morning, Alan Aaron, representing the appellant Samuel Ho. In every case that I could find that addresses the direct issue presented in this case regarding the admission or denial of admittance of business records, the records which were attempted to be introduced into evidence were introduced or attempted to be introduced by a person who was in a position other than the plaintiff in this case. In those cases, the records were introduced or attempted to be introduced by a person creating the business record, the keeper of the books and records of the business or person, keeper of the books and records of the business, or a person with knowledge or personal knowledge of the business records and how they were kept. In the present case, the lower court allowed the person receiving the records from a third party to testify that the records received by the plaintiff were plaintiff's own business records. The plaintiff should not have been allowed to testify over objection that the records received from third-party contractors not present in court were the plaintiff's own business records. These were records which the plaintiff did not create.
Couldn't the judge have just relied on Paul Littman's testimony about what invoices were paid?
I'm sorry?
Couldn't the judge have reached the same result by relying on Mr. Paul Littman's testimony concerning the amounts paid by ADA?
Mr. Polliman had no personal information regarding who created the record, what was in the record.
His testimony isn't the record, though. His testimony is his testimony.
I'm sorry, his testimony? It's my fault with
He
my hearing aids.
testifies separately when he's putting in the records. The judge, you're saying the judge couldn't rely on these invoices because they don't satisfy the business record exception.
Correct.
But if his testimony has the same content to it, i.e. ADA paid X company this amount of dollars.
Right, but what did they pay them for? I had no opportunity to cross-examine the person who either did the work or created the document.
Right, but I guess Justice Meade is getting to what's the prejudice here? Because if the records come in to show ADA paid these amounts, and Mr. Polliman can testify, I paid these amounts, what's the harm? Even assuming that you're correct on the business record.
But we don't know what Mr. Polliman paid these amounts for. Mr. Polliman received a document from a third-party contractor.
He certainly has personal knowledge. I paid this company to do work on X, Y, and Z. And that's not
But we don't know
hearsay.
that, we don't know that the work, that Mr. Parliament can't testify that the work was actually performed.
He can testify as to his knowledge of what he hired the contractor to do, and maybe he observed what the contractor did.
Fine,
that's all
but we don't know
personal
what the
knowledge.
we don't know what the contractor did. And I have no opportunity to cross-examine the contractor on the work that was actually done, if any, the fair value of the services, for instance, the contractor's normal rate, what hours he spent. I had absolutely no opportunity to cross-examine the person who did the work. So we don't know, and the court doesn't know exactly what was done.
I'm trying to understand what you think the prejudicial impact of these records was. If it's not the amounts, what else? Is it the description of the items in the records that's prejudicial? Because
I mean, the prejudice comes into play with the fact that I don't know what work was done. Mr. Parliament didn't testify as to what work. Mr. Parliament testified that, yes, I received this document, I paid this document. That's it.
if I pay someone to come and fix my refrigerator and pay them $400, I can testify I paid $400. My understanding is that the person did this to my refrigerator. That's all personal knowledge, right? So what else is missing here?
Mr. Parliament can testify, yes, I paid this person $400. For what, though? If he's basing it on a document that someone else created, that's hearsay. And it's not subject to the business records exception.
Was there a separate objection apart from the business record exception objection to his testimony being hearsay?
I just think I objected to that whole line of questioning. And without the business records, again, I'm severely prejudiced by the fact that I have no opportunity to cross-examine any of the contractors.
Your brother says in his brief that every case you rely on doesn't stand for the proposition you cite it for. And the one that does has expressly been, the SJC has expressly declined to follow it. And
No,
you
I
didn't file a
disagree.
reply brief, so.
In every case that I have cited, and especially Nations Bank versus Eisenhower, which is right on point, the documents that were introduced or attempted to be introduced, regardless of whether or not the court allowed it, were attempted to be introduced by a third party who either created the document, an agent servant.
I'm sorry to interrupt. This is the case that Mr. Freywitzer says the SJC's declined to follow it 5 years afterwards in Beal Bank SSB. They said that the appeals court's interpretation was overly stringent and that the business record exception is to be construed liberally, and they were not going to follow that.
But again, I cited about 8 cases. In each one of those cases, the records were introduced by someone other than the equivalent of Mr. Pollittman. They were introduced by a third party who either created the document, who was an agent, servant, or employee of the business that created the document, or someone with personal knowledge of how the document was created and what led up to the creation of the document.
That seems to be what the SJC disapproved of. If a company has work done for it and they get an invoice and they put that invoice in their company records,
right?
And it's prepared by someone else, it's a business record of the company.
Correct.
So how is that different from what occurred here?
Because an agent, servant, or employee of the company or the keeper of the books and records of the company can testify, and there's cases on that. And we further have the issue of the judge's required findings under 23378, which don't exist. But in each case, it's someone other than the equivalent of Mr. Pollittman introduced the records into evidence, or attempted to introduce the records into evidence, whether or not the court accepted it or not. The fact of the matter is that someone other than the Mr. Pollittman in that case introduced.
All right, well,
the
so that's
records.
what happened in Quinn Brothers. In Quinn Brothers, there was a whole bunch of invoices that were established only by the testimony of the company receiving it and not by the people who generated the invoices. And the SJC said those were business records. Why is this different?
I'm not familiar with the Quinn Brothers case, I'm sorry, but I am familiar with the A case, and I can't tell you that it's distinguished or otherwise. I can just cite the cases, including Nations Bank, including Emory Air Freight, and the 6 other cases that were cited, which support my my argument on appeal. I mean, further, Judge, the statute requires the court to find that the document being introduced was made in good faith in the regular course of business, and that it was the regular course of business to create such a document, and none of those findings were made. In the present case, the trial judge made none of the required findings, and without the creator of the document present or a person with personal knowledge, it was impossible for the judge to have made those findings. The judge, based on Mr. Pollittman's testimony, could not have made a finding that the document was made in good faith or in the regular course of business.
Do you have any defense to the claim for appellate attorney's fees? Your friend's asking for appellate attorney's fees under the lease. Do you have any defense to that?
I understand that the lease does allow for attorney's fees. Okay. I will admit that that is part of the record. Mr. Pollittman couldn't testify under oath that the document had received was made in good faith or in the regular course of business, and that it was the regular course of business to create such a document. Mr. Pollittman did not create the document, it only received it, and there was no person present in court at the trial that could testify that the document was made in good faith. These are findings that are required to be made by the court in order for the business records exception to hearsay rule to apply. Further, 23378 goes on to say that the court should have required the party offering the document to offer the original document into evidence, and the original document was not offered. In addition, under the statute, the court should have required the person creating the document or a person with personal knowledge to appear and testify. No such person were present. These are the requirements under the statute.
I don't understand the original document thing you just said.
I'm sorry?
You just said the original documents weren't presented. How do I know that? What makes these not original documents?
I mean, the original documents would have to have been introduced by the contractor, the person creating the document, or an agent, servant, employee of the contractor, or someone with personal knowledge as to how these documents were created. Okay?
But you acknowledge that if there were evidence that ADA received these invoices and filed them as part of its overall regular course of business, that if there were evidence on ADA's end about that, that would satisfy. You don't have to have evidence just from the originator of the invoice. The receiver of the invoice can be, as long as those invoices come in and are part of the regular course of business.
That might have been part of ADA's business policy to receive a document and put it in its file, but it doesn't mean that the document itself should come into evidence, because it's not a document that ADA created, and it's not a business record of ADA. It's someone else's business record.
I do think there is some case law, Quinn Brothers is one of them, that sort of says you can have business records on the receiving end if they're done in a certain way. Now, I'm not saying that that foundation was made here, but it does seem, it's not, business records isn't just limited to the creator of a document.
I mean, it's nothing more than a document that ADA receives and puts in its file in its regular course of business. But the document itself, the creation of the document, was not part of ADA's regular course of business. It was someone else, it was the contractor's regular course of business to create these documents. And no one was present, and there was nothing to prohibit these contractors from coming in and testifying that, yes, I did the work, I created the document was created, it's a regular part of my business.
Well, I mean, other than the efficient running of a trial, the reason we have a business record exception is that we don't have to bring in all those people. But let me ask you this, when ADA took someone else's invoice and stamped paid on it, why doesn't it become ADA's document? A record.
It may become a document of ADA, but it does not mean that the document was made in good faith. And
What evidence of
ADA can't testify just because they put a paid stamp on it.
let me ask you this. What evidence is there that any of these documents were created in bad faith?
I don't have to prove that. They have the plaintiff has to prove.
The judge admitted them. Why isn't it assumed that the judge made that implicit finding?
I think the judge was wrong in making that finding.
Well, I understand that, but why isn't? I understand your argument, but why isn't it implicit in his accepting these documents?
I mean, the documents have to be, again, forgive me for repeating myself, the documents have to be introduced. They were created by someone other than ADA. And
We're gonna leave it there. Your time's up.
sorry?
Your time is up.
Okay, thank you.
Mr. Freywitzer.
Good morning, may it please the court. My name is Evan Freywitzer, and I represent the Appellee ADA Management Services.
Could you just reorient that mic? Thank you.
Is that better, Your Honor?
Yes.
Proof of ADA's damages actually did come in two forms. They came in the form of the invoices that my brother objects to, but they also clearly came in the form of Mr. Pollittman's own testimony.
Is that objected to?
It was not, Your Honor, and
I didn't see him testify to any numbers, though. He testified to paying, but I didn't see in the transcript him saying, I paid $12,321. Did I miss that?
Your Honor, what happened repeatedly throughout the trial, and it's in the transcript, is Mr. Pollittman was asked about a particular damage. For example, the creation of a door in a retaining wall. He was asked if he had to repair that. He was shown the invoice. He was asked if that was the invoice that represented the repairs. He was asked if the invoice was paid by ADA management. And each time he testified, yes, it was, yes, it was.
I just don't see, and maybe I'm missing it, how the judge could get the number he got without using the records.
I think that he would indeed need to use the records, Your Honor. But of course, if you look at the invoices themselves, which start on Record Appendix, page 21, as Justice Toone noted, each one of the invoices either has a copy of the check attached to it, the payment check, or is stamped paid, has the check number and the amounts written down. So the invoices themselves, along with those other things, are the business records.
Well, what foundation was made to say? I think the case law could allow that. I don't think it has to be, contrary to your brother's argument, just from the creator. but you have to have evidence of the regular course of business, these documents being gathered and collected and processed in that. I'm not sure there is that foundation in the record. You know, just saying, I got this invoice, that doesn't satisfy the foundation requirement for the rule. So what is there to sort of say this was done in the regular course of business on ADA's side?
Each time that one of the invoices was introduced into evidence, Mr. Poltman testified that he received the invoice, he received it in the regular course of business, that it was the type of a record that ADA would normally keep, that he did keep it in the normal course, and I guess in response both to your question and to my brother's argument that there aren't those findings, number one, it's not an actual argument that was preserved at trial. The objection was simply, these are not ADA's, these are not documents that ADA created, and so they're not ADA's business records. It was not a foundation objection, nor was that objection made in his motion in limine. Secondly, Commonwealth versus Andre 484, Mass 403, clearly says that the decision to admit the records implies the requisite findings by the trial court. And if neither one of those things were enough, there was a motion for a new trial. And in ruling on the motion for the new trial, the judge specifically said, and I'm reading from it, Your Honor, here for each invoice, Mr. Poltman testified that ADA received and kept the invoice in the regular course of business, that it was made contemporaneously with the events described therein, and that in response to each invoice, ADA paid the third party/contractor for the work completed. Under General Laws, Chapter 23378, ADA's records of the invoices were admissible under the business records exemption to the hearsay rule. There's no requirement that the representatives from the third-party contractors who created the invoices testify for the records to be admissible. So even if it wasn't implied, as the cases say it is, just by the trial judge's admission of the records, the trial judge specifically and explicitly said that the points required for admission under 23378 were met. And I guess in a way, it comes down to what I think of as confusion as to whose business records they are, because what the cases are very consistent in saying, I think, is that the business records, invoices in particular, can be the business records not only of the company that created the record, but also of the company that received the record. I think that is what Beal Bank stands for, and a lot of the cases build on Beal Bank. Beal Bank, the court said, the business records of one business are admissible as the business records of another business, where such records are integrated into the latter business records and relied on. ADA relied on these, they paid them.
Usually there's some evidence of kind of a system on the receiving company's end, right? Some kind of system where invoices come in and they're processed and go out. And it seems like maybe there was a rudimentary recitation of the elements, but not necessarily evidence as to this is how ADA processed.
It is not a big business, Your Honor. It's a small family business. It's Mr. Poltman, his wife, and their son who run the business. Do they have a procedure? Yes. The invoices come in. Mr. Poltman writes a check. As you can see, he very often copies both the check and the invoice together, so he has a record. He keeps them as a business record, and that was essentially what his testimony was. I do think that the cases that we've discussed, the Beal case, in particular, the Quinn brothers case is right on point in saying, look, the trustee, in that case it was a real estate trust, and the trustee said, look, we get the invoices, I pay the invoices, and these, we keep them in the regular course of business. And on that basis, the Supreme Judicial Court said, yes, they became the business records also of the realty trust, and that is precisely what happened in this case. We cite, and I don't think there's any benefit to going through all of the cases, but we cite 3 or 4 pages worth of appellate level cases in which the courts consistently say the business records of one business can become the business records of another business if they're received, if they're relied upon, and if they are kept in the ordinary course. And I don't think that there's any question but the trial judge made those findings in this case, and it is a question of whether or not the trial court abused its judgment, its discretion in admitting it. I can't see how that would possibly be the case here, given the testimony and given the records and given the extensive case law that allows for this type of admission of the business records.
Counselor, at the end of your closing argument, you added up all the amounts and you added up to the $69,000 and change, and you said, but of course, you got to deduct the $9,000 for the retained security deposit. And the judgment isn't the $60,643.45 that you asked for, but the $69,000. What do we do about that?
Your Honor, I don't have a good answer for that, other than if the court were to look at that, this court is in just as good of a position as the trial court was to say, well, the $9,000 should have been excluded, if this court feels that the $9,000 should have been excluded.
I mean, you said it should be excluded, right?
I think that is correct, Your Honor. There were some other questions that were raised by my brother in his brief, one of which involved the question as to whether or not the defendant was due a set-off for certain amounts that he alleged were overpaid.
Could I ask you for a favor on that? We don't have Exhibit 13, the rent payment ledger, and I assume that's one of your documents. If you could provide that to us,
Be happy to do so, Your Honor.
that'd be really helpful for me to see that. It's much easier. It was hard to follow the testimony without looking at the document they're following.
The simple version of that, Your Honor, is that my brother did elicit testimony from Mr. Pollittman on cross-examination that ADA received 39 checks for a 36-month period, and then on redirect, it was pointed out to Mr. Pollittman, and Mr. Pollittman testified that 3 of those checks had been returned for insufficient funds, and that is the reason why the court, the trial court said there was credible evidence that ADA ultimately was only paid for the 36 months. The only other issue, Your Honor, is, as you've noted, we have asked that we be granted our reasonable attorney's fees. The lease provides for the payment of such attorney's fees. I'm happy to answer any other questions, or I'm happy to submit on the brief.
I just have one last one. Is it live noodles or live noodles?
I'm sorry?
The restaurant, was it called live noodles or live noodles?
I could let my brother speak to that, but I believe it was live noodles.
All right. Thank you.
Thank you, Your Honor.
Things that keep Justice Ditkoff up at night.
Thank you, Your Honor.
With that, we'll take it under advisement. We're going to take a short recess. Our next case is 25P355 Hinkley versus Gunter. Mr. Grilli, did I say it right?
Yes, Your Honor. Thank you. Good morning. May it please the court. Michael Grilli for the appellant Carole Hinkley. This case, Your Honors, emanates from an action which was a complaint in equity filed by Ms. Hinkley to address the issue of retroactive child support for a period of time, specifically November 29th, 2018 through July 2nd, 2019. There had been some superseding judgments issued by the Probate and Family Court. Ms. Hinkley filed a complaint in equity to address retroactive support for only that period of time. During the course of the litigation, there was also a modification case that was pending that was subsequently resolved. Both cases were being litigated simultaneously after the after the modification case ended. It was only the equity case going forward. She got retroactive support up back to July 2019, right? Correct.
And that's because the statute kind of cuts off to the filing of, when there has to be a pendant
Correct.
complaint for modification.
Correct.
So it's just
because,
this like kind of narrowish window of
correct.
Okay.
The complaint that was resolved in 2014 was filed in that July of 2019 span of time.
Yeah.
So the court was able to order retroactive support back to the 2019 date, but nothing prior to 2019. Ms. Hinkley then filed a complaint in equity to address that. The court, in its decision, primarily based its decision as if this was not a complaint in equity, but treated it as if it was a motion pursuant to Rule 60B, in that it was not disputed that the action was not filed within the year as set forth in the statute, but that since it was filed more than a year after, there needed to be fraud upon the court in order for Ms. Hinkley to obtain relief, as opposed to the complaint that was filed that asked the court to use its general equity powers to grant her relief, thereby providing her to meet a much higher standard at trial. It should be noted that the litigation of the complaint in equity went on for 3 years, and it was not until the morning of trial that the court even addressed the issue as to the standard that was going to be applied at the time of the trial. Well, she filed it under Rule 9B, right?
Correct.
And that's clearly not the right rule, right?
Correct.
So you go into trial, I know it wasn't you, but you go into trial and the judge is like, I got to make sense of this. 60B is the only sort of thing I see here. And so he proceeded under kind of a 60B3 analysis. You agree 60B3 doesn't work because that's time barred, right?
Correct.
So then he says, well, to go beyond that, you really have to have this kind of really high showing. And that was sort of the frame that the judge put the case in.
Correct, though the judge did note in his decision, and referencing Your Honor's mention of Rule 9, that the judge said he's not going to take any action on what he perceives is perhaps a deficiency in the complaint, in that the case is going forward under Rule 60B and rules of equity. So he, to some extent, our position was and is.
Well, the rule has equity principles to it.
Correct.
Did she mention the 215-6 at the hearing?
Yes. Yes. In that, at that point, in fact, trial counsel thought that the judge had perhaps taken an inappropriate or the wrong position, actually asked the judge to recuse himself prior to the trial. The judge obviously declined that and went forward. And our position is that the judge should have applied the equity standard and not the higher standard of fraud upon the court, in that certainly the court has...
Where is that in the record where she asserted that this doesn't fall under 60B, this falls under general equity authority under 215.6.
I don't recall the specific.
'Cause I don't think that's there. I don't think she made that argument.
So we would say, Your Honor, that certainly under equity jurisdiction, the court has powers which are broad and flexible and certainly can take actions to afford relief that's in the best interests of the person. So our position is the court, that's the standard that the court should have applied going forward here, in that it was clear from the history of the case, from the evidence that was presented, that the opposing party took significant steps to try to defeat the plaintiff from getting the necessary financial documentation in order to produce his true level of income. There had been numerous discovery orders. There was the appointment of a discovery master. He had admittedly, findings are by the court, had submitted financial statements that didn't truly set forth his income, didn't set forth VA benefits that he had been entitled to and was receiving. And I think that's important to note, in that part of what was set forth by the court is that Ms. Hinckley could have engaged in discovery to get this information, if not from the gentleman himself, but from outside sources. Given that his primary source of income was VA benefits, they were outside of the subpoena power from Ms. Hinckley and counsel, and we had to rely on documentation that he provided to us.
Couldn't you get an order requiring him to file a release or to get the documents and give them to you?
Correct, and that was late in the process, and that was the only means by which the discovery master entered an order requiring him, and the judge approved that order requiring him. But this was very late in the process at that point. At this point, we had engaged in substantial discovery that to some extent gets to the issue, and I'm kind of getting a little bit ahead of myself, as we relate to the issue of the judge in awarding fees to the opposing side basically said that plaintiff's counsel engaged in a long, drawn-out course of litigation when, at the end of the day, there was really only a small amount of money that was in controversy. I believe his finding was approximately $3,200 would have been the amount that she would have been entitled to. We had no way to ascertain what she would have been entitled to because throughout the process, we were unable to get the documentation that was necessary in order to support our claim that he had been
Well,
untruthful.
the judge says that the mother did not seek basic discovery at all, did not seek discovery as to find the income of the father. He says that's very typical. You know, you trust but verify the other side's financial statements in divorce proceedings, right? And she didn't make any of those requests at all. There was certainly evidence that there was a possibility that the father was not being completely forthright, and that just as a matter of equity, you know, the mother should have done more to sort of file discovery requests, seek this information, and verify at the time.
And that was accurate, Your Honor, during the period of time when the mother was pro se. However, once mother obtained counsel and this action was filed, discovery was engaged in, and there had been numerous discovery orders relative to this that father did not comply with until such time as he signed the release enabling us to get documentation directly from the VA.
The judge ordered him to file an updated financial statement, right?
Correct.
And that was due on January 6th of this year.
Correct.
And did he file that?
He did file an updated financial statement.
And wife was ordered to respond by the 9th, and she did not.
Correct. Correct, Your Honor.
Was she pro se then?
What was the date, Your Honor?
January 9th, she was supposed to respond. She waited more than a month after that to respond.
She was represented at that time. She was represented by that time. In addition, we argue, Your Honor, that even if the Rule 60 standard is the correct one to apply, that father did, in fact, commit what we would argue is a significant fraud upon the court. Certainly, it created a situation where he consistently provided inaccurate information or no information, not just one or two times throughout the course of the litigation. The judge felt that it didn't rise to the particular level necessary to support the claim. We argue against that. We say that it certainly did. The judge made mention of the fact that he did not feel that there was manifest injustice in this case, because he did an analysis and said that given our client's financial circumstance, the children of the parties did not suffer by virtue of the fact that she did not receive the $3,200. I don't think it's appropriate to say just because the children of this couple, given our client's financial circumstance, did go without because they didn't receive this extra $3,200.
Isn't it largely a credibility determination, though, when the judge basically says the father's got some sloppy accounting, but it wasn't his intent to pull the wool over anyone's eyes?
I think, Your Honor, there is some manner of credibility here.
So how do we second guess that?
I think just given the findings where the judge basically found, in large part, if not for the higher standard, the judge found that certainly there had been a level of fraud. The judge just felt that it did not.
He said just the opposite. He said it did not rise to the level of fraud.
Well, I think he said, Your Honor, that we had to prove something more than common law fraud. We had to prove something more. So it was a higher standard than simple common law fraud that needed to be proven, and he felt that we did not rise to that level.
He said that he couldn't conclude under the circumstances that the defendant's misconduct was deliberate and calculated to mislead and defraud the plaintiff or the court. So that finding kind of says you don't even satisfy the B3 standard, much less kind of the higher fraud on the court standard.
But I think, Your Honor, to some extent, that's contrary to the evidence that was presented, and the judge.
What in particular? I mean, clearly he didn't reveal this income, right? So we can all agree to that. But like, what other evidence can you point to sort of say there was kind of fraud, despite the judge's finding that there wasn't?
Well, given that he was aware, he didn't disclose income. Okay? He didn't disclose benefits that he was receiving. There was a period of time where he led everyone to believe that he had the ability to work and, in fact, was engaging in a job search when he knew that he had already been determined to be totally disabled. Had he acknowledged that he was totally disabled, then certainly that would have led then the next question as to your total disability, what other benefits might you be entitled to? In fact, I believe he engaged in a job search for over a year, knowing that he was unemployable at the time. So, and last thing I want to touch on is my time is winding down, and I appreciate that, Your Honors, is that relative to the issue of fees, one, our position is that the mother, to some extent, we feel, based on the evidence, did prove some manner of, whether you want to call it fraud or omissions on the part of the other party, and as such, should not have been obligated to pay his fees. To some extent, again, the judge made a finding that, given the small amount that was in controversy, she expended considerably more than, and everybody expended considerably.
Isn't this provision usually used, as it was here, to shift the attorney's fees from the wealthy party to the destitute party? Why isn't that? That's one of the things she found too. Why isn't that within the discretion to say, we got a destitute party and a very rich party, so the rich party has to pay the attorney's fees of the destitute party. What's
Then
wrong?
I think it's a situation wherein you have to look at some of the findings, in that our position would be Mr. Gunter did not have clean hands and therefore should not benefit. And I think that's certainly within the discretion of the court as well. And lastly, the submissions by trial counsel included time spent both on the modification and on the complaint for equity. The judge only made an award under the complaint of equity and went through what we see as some sort of analysis on his own in order to determine what the appropriate amount of fees are, when it wasn't clear from the submission that all of the fees submitted were exclusively for the equity action.
Justice Toone has a question.
Thank you, Justice Meade. Just one, going back to the merits. So there's the B3, 60B3 analysis.
Yes.
That's untimely. Then there's kind of the fraud in the court, kind of residual analysis that the judge applies, presumably under 6B6, yes. I'm guessing. What is the standard that you think the judge should have applied, assuming that this was, what would be the standard for just a straight up equitable authority? Like, what should be the rule that the judge applies under that analysis?
That there was an injustice in this action, and that the court has the ability through its equitable remedies to correct that injustice.
Thank you.
Okay, thank you. Ms. Amaro.
Your Honors, thank you very much.
Good morning, Your Honors. May it please the Court. Catherine Amato for the appellee, Michael Guntor. Your Honors, very simply, there was no abuse of discretion by failing, by the courts not granting the mother in this case relief pursuant to its equity powers. First and foremost, and something that was raised by a couple of Your Honors when my brother was speaking, was the fact that at trial, mother was represented by experienced, competent counsel and failed to raise the issue of 215 Section 6. When the discussion was had about bringing this under 60B3, which is the obvious section that this would fall under, despite the time frames, there was not an objection. It wasn't raised. So my primary argument in my brief is the fact that this wasn't raised. It's being raised now, and frankly, the legal authority for the last answer that my brother gave doesn't really answer the question. What's the claim? What authority does the court have beyond 60B3 and the exceptions that are built into the case law?
You may be right, but the first line of the judge's decision is the court held a trial on the complainant equity, General Law C 215 Section 6, filed by CAROLE, HINKLEY, right? And
the judge did address it.
So the judge kind of raised it at the very start.
Yes.
And there does seem to be, at least under the Sanagate, I'm not sure if I'm pronouncing that correctly, some authority that you can have an equitable restitution claim that goes beyond the confines of Rule 60B. So could you just address that? Why wasn't that issue kind of teed up in some way for the court?
So I think it was, Your Honor. So to answer your point, yes, the judge himself raised this independent action. So even though counsel didn't raise it, the judge addresses it in his judgment and in his rationale. And what he says is, look, this falls within 60B3. We're past the year, and so now we look at the Sahin case, 435 Mass 396. We also look at guardianship of Ingrid, 102 Mass Appellate Court at page 12. And that's where, if it's brought in excess of a year after the judgment, the plaintiff must show something more serious than the common law fraud. And that's what the court looked at. And that's where manifestly unconscionable comes in. And that's where a grave miscarriage of justice comes in under that case law. And the judge did that analysis in its rationale and found, I think appropriately so, given the facts of this case, that those factors were just simply not met. And makes findings of the sort, despite the fact that mother didn't raise that in the lower court. I think the judge addresses that under the understanding that this case falls within 60B3. Doesn't fall within anything else. There's additional language in 60B3 that it doesn't prevent the court from finding an independent action if you're beyond the year. Also addresses fraud on the court. So I think that counsel is conflating those two separate causes of action, right? Number one, what Sahin tells us about you're beyond a year, you need to show something more, the unconscionable, the manifestly unjust, and the judge addressed that. Number two is sort of separate and apart, which would be showing a fraud on the court, which they have failed to do based simply on case law, Judge.
That's still, my understanding, that's still Sahin and.
It is, Judge.
They still kind of falls within the 60B. It seems like there could have been a separate argument under Sandegate that you have a separate claim for restitution that's wholly independent of 60B. I'm not sure that was made here, but that would be, I think, the strongest argument, that there's some independent avenue.
And I don't think it was made here, Judge, but I will say that it would be problematic, and this is in my brief, to be able to circumvent those timeframes, particularly the time frame with fraud on the court, which is precisely what they are arguing, is this was a fraud on the court. Fraud, I should say, not fraud on the court, a fraud. It would be very problematic to be able to circumvent that rule and those time frames, and then the heightened standard if you miss that time frame, if you were able to bring a separate cause of action, which I note they did not argue. Additionally, Your Honor, relative to my brother's statements about the judgment in the court noting that this information was available to the mother, and I want to be really specific about what was in that judgment. There were bank statements that showed this amount of money coming into father's bank account. So it was not as if you needed, yes, the unemployment records would have been helpful, but it's not as if you needed those to know that this money was coming into father. And I also note that the court made a finding that father's income was complex and sort of all over the place and in flux in this time period, which is not unusual in probate and family court hearings, especially with low-income folks. So he's on VA, he's waiting for his VA benefits to come in, he's applying for jobs, he's trying to apply for unemployment. So the court doesn't just find that he was misleading, but says it was misleading, it was sloppy, but it was also pretty confusing, and we're talking about I think it was a 30-week period. Very small sum of money in the grand scheme of what both of these folks have spent on these arguments. And so I think it's important to note that the court did not find fraud. The court found that he was misleading, that it was sloppy, but made mitigating findings as to why that might have been, and also puts the onus on, correctly so, on mother for not asking the questions that every litigant can ask, should ask in discovery, even basic discovery, which was not done. Your Honor, additionally, the mother was on, Your Honors, the mother was on notice as early as November of 2018. That father had been pursuing unemployment. That is also in the records. And again, no discovery was done, no follow-up was done by mother until very late in the game. As for the court's findings that there was no miscarriage of justice, the court notes a couple important things. First of all, the children, we're talking about a little over $3,000 in the whole scheme of the child support orders in place. So mother received a significant amount of child support over the years. This was one period of time. The children went to college on the GI Bill as a result of father's service, and that was a mitigating factor I think the court looked at. The court also found that the children didn't go without, in any real substance, relative to a 30-week period of a partial underpayment, not a non-payment, an underpayment of maybe $100 and something a week. Mother's financial circumstances at the time and now far exceed father's. Father is destitute. Mother has over $1 million in assets. These were important to the court in exercising discretion in this case, both on legal fees, but also in determining whether an injustice had occurred.
Just on the issue of fees, I get all that. It still seems a little harsh to award, $16,000 in fee, where everybody agrees that your client withheld money in child support, right? And it's just a question of whether or not the mother could recover that money and sort of say, no, you can't, and also you've got to pay 4 times that amount of fees. Maybe within the judge's discretion does seem a little harsh under the circumstances.
And what I would say to that, Your Honor, is a few things. First, the court, it's a third of the total fees. It's not half. So that whole analysis between this equity action and the modification, the court was very conservative in its analysis of how much it did order mother to pay. I think secondly, the court consistently tried to not advise, but put on the record that the amount of money at issue here and the requirement, the findings that the mother was going to have to convince the judge to make were unlikely to be met. And yet she pursued, including through appeal. I think that when you look at the balances of equities and the fact that the court has the discretion to shift those fees, he was conservative, and it very frankly wasn't a surprise to mother at that point that they were going to be shifted, given the tenor of the litigation up till then. It wasn't, I don't think it was a surprise. Additionally, Your Honor, the mother didn't file her argument timely. So to Justice Meade's question about those deadlines that the court had, my client filed his financial statement, his updated and corrected financial statement earlier this year. Mother had a deadline to meet, and she was represented by counsel and did not meet that deadline. And I think that was significant in the court's decision to offset some of the fees that my client had incurred as a result of this litigation.
Counsel, you have asked for appellate attorney's fees,
I have, Judge.
but you already got an order for appellate attorney's fees from the trial court.
I did, Judge. I got a modest order that doesn't come close to meeting the fees that my client has incurred in this appeal. And so I am seeking fees to make up for the deficit. He is extremely low income, and frankly, this far exceeds his ability to pay.
Okay.
I'll rest on my brief if there's no further questions.
Seeing none, thank you. Thank you
Thank
both.
you.
We'll take it under advisement.
Thank you.
Our next case is 25P43, Department of Children and Families versus Mother. As you know, this case is impounded, so please use pseudonyms or other indicators of people other than their names. Ms. Frotto.
May it please the court, my name is Cara Frotto, and I am here representing the appellant mother. The mother respectfully requests that this court reverse the juvenile court's decision terminating her parental rights. Your Honors, this case was about DCF and the juvenile court fast-tracking mother's case from removal of this child to the termination of her parental rights was unusually fast. The trial was removed in April of 2023, and mother's rights were terminated by January 2024. Trial began in November 2023. This case is about a mother with a history of DCF, and there were allegations piled upon allegations against her with her speech that was not agreeable to the DCF or the trial judge. Just because a parent has a history with DCF does not mean that they don't have the fundamental right to family integrity, and it does not mean that this child's fate should have been sealed the moment DCF learned this child existed in Massachusetts with the mother. What we see in the record is the child was born in September 2022. Mother had prenatal care. She and her doctors detected this child had a heart condition. Mother arranged her labor and delivery from the Springfield area or Northampton area where she had been residing. She arranged to have her baby at Boston Children's so there would be the immediate surgery for this child after her birth. Now, The trial court in the findings, they make note of mother's lack of care, prenatal care on some of her other children. That was not the case with this child. This child had prenatal care. This child's serious condition was detected, and mother addressed those conditions before the child was born and up and at the birth. The child spent weeks at Boston Children's Hospital with the mother there taking care of her at her side. We have no 51As filed against the mother for her care or attention to this child. We have the mother then deciding that she was going to move to Kansas and discuss that with the child's doctors, knowing this child had just had heart surgery weeks before, and at no point was she told that she should not go to Kansas with this child. So mother went to Kansas and resided there for a few months. When DCF learned of this baby, after mother had moved to Kansas, DCF referred over to Kansas for a well-being check and a check of this baby. Kansas Protective Services investigated the mother and the baby and found that mother was meeting this child's minimum basic needs. At some point, mother moved back to Massachusetts, and DCF learned that this child was here in Massachusetts with the mother. And upon learning that, immediately went to the apartment where mother was and removed the baby. Despite their own investigation showing this child's needs were being met, the home was clean, mother had enough provisions for the baby, and we have no indication that the child's medical needs weren't being attended to, as we had evidence that the child wasn't due for any further cardiology appointments at the time.
Did mother comply with any of the action plans?
Your Honor, I'm glad you asked the question about the action plans. Here we have DCF regurgitating old action plans of the mother. There was no new action plan created. As we see within the action plan tasks or on the action plan itself, DCF did not update mother's last name.
Did she comply with the old action plans?
In the old action plans that she had for her other children, the allegations within the complaint or in the record is that mother didn't comply with the tasks. Mother argues that the tasks weren't related to her and her needs. And she argues, and we argue here on appeal, that the tasks didn't have a nexus to any alleged deficiencies of the mother. So what we have is this case we feel is following the adoption of Zoltan case, where it says that the nexus for the action plan tasks themselves need to be directly connected to the alleged parental deficiency.
Which wasn't connected?
Well, Your Honor, one of the arguments within the record, or in the record in that trial, was that mother hadn't had any substance abuse treatment. And what we see throughout the record is that there is no evidence that with these children, or with any of her children, that she ever was under the influence and unable to meet the children's needs due to any alleged drug or alcohol use.
When she moved to Palmer from Kansas, the testimony was that she was intoxicated all the time.
That is not what the Kansas Child Protective Services.
Kansas, when she moved to Palmer, Mass.
I'm sorry, when she moved to Palmer, there was allegations levied against her, and we have nothing but those allegations. We have no evidence of those allegations. And those allegations being within a 51A report, the judge herself, through her initial rulings at the beginning of trial, in response to any motions in limine filed by the mother, where that 51A reports were going to be admitted under case law for setting the stage only, meaning why are we here? They're not admitted for the truth of the matter asserted within those 51A reports. So we don't have any evidence that mother was, in fact, under the influence all the time.
The Kansas roommate told DCF that mother was using all her money for drugs and alcohol, and the child would regularly be left screaming and unintended. Why isn't that a nexus?
The reason that's not a nexus is that the Kansas Protective Services did investigate this child, did investigate the mother, and did investigate the home, in Kansas. They did not have any evidence to support those allegations. So this roommate, who also had a bias against the mother for having had a falling out with the mother, had also left the home that she shared with her months before ever speaking with DCF. So she was not there after, I believe, somewhere around January, I believe is what the record showed, that she had moved out. And we are into April and May with the time that she is talking with DCF. And at that point, Kansas Protective Services at that time had already investigated the mother in Kansas, had already investigated her caretaking of this child, and didn't see any evidence of any drug use or any connection to this child not being cared for and her needs not being met. So if we continue on back to Justice Meade's questions about the action plan as well, we have allegations, and the judge made findings based off of untreated mental illness. However, within the record itself, we don't have any we have no diagnosis for any alleged mental illness of the mother. What we do have is findings based off of some police reports with unidentified sources. So the judge's rulings, again, the judge was sloppy, and by ruling that unidentified sources and hearsay would be struck, but then making findings reliant upon them, so the issues regarding any suicidality of the mother, I think there were 2 anonymous reports to the Northampton Police Department, and by the judge's own ruling, those should have been struck, but yet the judge made findings based off of those rulings. Now, we also have, I believe, a note within DCF records about when one of her sons was removed immediately at birth, simply because the other children had been removed, where her supposed mental health concern at the time was that mother remained in the relationship with the father, although there's no allegation or no indication as to why that is a mental health concern and what the alleged deficiency of mother's parenting was. What we have is that no point in time was mother so-called untreated mental health or undiagnosed mental health affecting her ability to meet the needs of any of the children that she had. The older children were removed because of an alleged domestic violence incident in a shelter in Holyoke, an incident where we didn't have any witnesses. We had shelter staff who thought they heard something and thought they heard something about somebody or something falling down the stairs, and then waited 2 hours to call DCF. And that was why those children ended up being removed, and every other child mother had after that fact was removed, either immediately at birth or as soon as DCF learned that child was in Massachusetts with the mother, such as this child. We turn our attention to the second part of my brief, where it discusses mother being punished here by the trial judge and by DCF through her speech and her actions, through her speech while she was in Northampton.
Was this raised below?
Excuse me?
Was this raised below?
Well, mother was arguing the issue of these arguments that these police reports should not be found unfit. But she didn't make the specific argument that it was protected speech. But she didn't know how the judge was going to take all of these arguments. And the judge...
There's post-judgment motions were available to her.
Excuse me?
There were post-judgment motions available to her to raise this.
I suppose that mother could have filed a motion for a new trial, but here has chose not to and was just looking to file an appeal and raise the appeal based off of the judge's findings that were done and raise it in totality and in combination with the rest of her findings.
What you've done is raised a very complicated constitutional claim for the first time on appeal with no the judge below.
Well, the the trial judge is still bound by the Constitution in making her findings at the juvenile court level.
She should get notice of that claim and be able to respond to it.
Well, we would argue that she is on notice by the First Amendment and Article 16 that speech is not to be, free speech is not to be abridged.
I think we're missing each other.
Perhaps what the judge did not do, which she should have done, whether this specific argument was argued to her or not, if she was using all of these issues within her findings, she made no connection and no nexus as to how any of the speech...
Did she find her unfit based on the things she said or her behavior and anger towards, say, for example, DCF workers?
Well, she found her unfit in conjunction she took it all in totality, but she used arguments within her findings about mother's temperament based off of the time through in Northampton. And you also made lots of findings based off of general criminality, or as she phrased it, unparental. Her unparental behavior and her temperament, and that's all in conjunction with how she was speaking within to the police officers. There's really only, I believe there's only one note in the record about mother starting to raise her voice to a DCF social worker.
That's part of the problem of what not raising it below illustrates, is that when speech and conduct are intertwined, it would be helpful to a reviewing court to know what the judge was relying on.
That I do agree that it would be helpful. However, here the judge is still bound by the Constitution and our speech and our requirements to not punish somebody for speech, and to still find a nexus between whatever the speech was that was supposedly harmful or would be harmful to this child and mother parenting this child today, where
But
we
that
have...
presumes the judge based any of her decision on the mother's speech instead of her conduct. How would we know that?
Well, within some of the findings where they're referencing different parts of the Northampton police reports, it's all in conjunction with what mother had been saying to different police officers and how mother had been acting and expressing her frustration with DCF, how she was expressing and verbalizing her frustration within the system and public officials within the system. And it was all made in conjunction, so it wasn't just a conduct of, well, this is how she moved, or this is, a face she made. It was all in conjunction with what was being said. And the judge made many findings, or detailed many times within the boundaries, or within the records from the Northampton Police Department about mother's speech. And then but failed to link that to any particular harm this child would suffer.
Thank you.
Thank you.
Mr. Cousins.
Thank you, Your Honors. Carlos Cousins for the Department of Children and Families. Your Honors, the juvenile court here properly concluded that mother is unfit to parent child, and that unfitness is likely to continue for an indeterminate period. The termination of parental rights is in child's best interests. Mother's history with the department dates back to 2004 and has resulted in the removal of child's 5 older siblings from mother's care due to numerous allegations of untreated substance use, issues concerning domestic violence, both between her and 2 partners in front of the children, or from those partners to the children without mother raising it to DCF or other authorities to protect the children. And it has included also issues with housing instability, criminality.
I was skeptical of your friend's assertion that this was all based on old information. And you come up here and you seem to be suggesting that it was in fact all based on old information.
No, that's not the case at all, Your Honor. This has continued through, there's a nexus for each of these 10 bases, and I can enumerate each in turn, on which the court relied here, that extend through the birth of the child and those that period in which a child was under mother's care, both in Kansas and in Massachusetts. The first that the court relied on is the untreated substance use. We see from the report, and this is in a 51B report, substantiated report, that a roommate of hers, there was two individuals that she lived with in Kansas, and that one of them observed mother after work drinking alcohol and smoking cigarettes daily, while the child was often left unattended, sometimes in a high chair and often in her back crying, while mother was not tending to the child. In one instance, she observed mother entirely passed out and unavailable to care for the child while the child remained on their back. That individual showed DCF pictures of the baby's neck, and there was a mark there suggesting that that was because the child was often left unattended in that position. Mother was often observed ill and leaving the child away from her and not tending to her. In addition to that, we have mother testified at trial that she consumed marijuana in order to treat a number of, yes, undiagnosed conditions, but that she herself identified. There was anxiety, depression, etc. Part of the reason that these have not been diagnosed is, in fact, that mother has not cooperated with the action plans and participated in services meant to address parental deficiencies for her to be able to better care for child. Mother, in fact, testified that she thought that two of the services that were potentially available to her, so those relating to substance abuse but also domestic violence, did not apply to her, despite this evidence and the court's findings regarding such issues. Regarding domestic violence, there is much in the record as well. At the time, or following child's birth, we have allegations raised by the same roommate and then confirmed by father that while father was holding child, mother attacked him. And we have a history as well of domestic violence involving father and the children, in which mother did not seek help, did not raise the issue with anyone. I heard opposing counsel today discuss one of the challenge findings regarding their stay at the shelter. That resulted in a 51B supported finding, and although there were no observations of whether someone may have fallen down the stairs, there were observations of marks on mother. There were reports by two children, including one of child's siblings, that the parents engaged in physical discipline toward the children. One of the children, which from a prior marriage of father, reported that they were physically disciplined every day. There are then, in this context, all of the police reports, many of which involved observations by the police, which were properly observed and relied on by the court. These involve both substance use and domestic violence. Regarding substance use, at one police report regarded father handing mother a bag which contained illicit substances, saying something to the effect of, "Here are your drugs." Mother was charged with Class D possession. Mother was also charged with intimidating witnesses on 2 occasions, and once defending a child. Mother was observed by police selling marijuana to minors, to teenagers at one point as well. And so this substance use history is dated, but it continues to the present. And this violence of temper could also properly be considered by the court. We rely in our papers on Ulrich, I believe, which Oh, I'm sorry, in Yvonne, I'm part, which involved verbal threats to DCF staff. They were loud and defiant in demeanor. During trial in Ulrich, too, there was verbal aggression toward counselors and children, and that was properly considered evidence of unfitness. And this is just one of the 10 factors which the court considered as together amounting to unfitness to parent this child. There is also the history of unstable housing. In the short life of child prior to this trial, that also is tied to visitation. Child was with mother for a time, and part of the reason that mother left to Kansas, she testified at trial, was to find housing for her dog. Very likely at the time, mother was seeking housing for herself. She lived with 2 individuals in Kansas, and upon returning to Massachusetts, and after the removal, mother was only able to attend 4 of the bi-monthly visits because shortly after that she had moved to, this time, Utah. This is the 3rd cross-state move that mother made, reflected in the record. Mother testified after moving that she did not think that it would be detrimental for her to continue visitation with child.
Can I ask you about the speech claim?
Yes.
I know you didn't write the brief, but are you at all concerned that this is being raised for the first time on appeal?
We are, Your Honor. We believe that that is improperly raised. We also believe that there is no free speech violation here. That
I understand the merits part of it. Yeah.
Okay. Yes. So we are as well concerned that it was that is procedurally improperly before.
What is your position on the, for my sake, what's your position on the merits of the first?
Yes. So our position is that there is no free speech violation here, and to the extent that free speech is involved, it is incidental to proper regulation regarding conduct. The issue here is mother's fitness to parent this child, and the interest, or the state's interest in the welfare of the children under its tutelage has to be weighed against any potential First Amendment concern. I think this is similar to, for example, having a regulation which says that you can't light a fire in a wood. That may mean that you also can't burn a flag, which may be some sort of incidental free speech violation, but that regulation itself is not violative of the First Amendment as a result.
Yeah, but can the department take into consideration a person's generally anti-authoritarian or anti-government views in sort of assessing their fitness? Is that, or is
that is not what the court does here. And the majority, or well, the bulk of the findings that are challenged in this regard have more to do with 51A reports that are not relied on for the truth. What the court is concerned with here is mother's parental ability. In fact, it says unparental conduct is what the court specifically identifies here as what it is concerned with. There are circumstances, of course, one can imagine in which the DCF would behave in a way in which it certainly merited, reproach, and that is not why mother is being, found to be unfit in this case.
Do you want to get that?
Thank you.
Can someone shut off that alarm? Is that ours?
I don't know.
Must mean lunch is ready. Mr. Campbell.
Good afternoon. May it please the court, my name is Alan Campbell, and it's my privilege to represent the subject child in this matter. And the subject child is asking that you affirm the decision below so that she may be adopted by her maternal grandmother with whom she's lived since she was approximately 6 months old. If I could jump to the First Amendment argument. I read it, I thought it was a very creative argument, completely baseless. It didn't actually dawn on me at the time, so I didn't put in my brief that it couldn't be raised for the first time on appeal, but I believe this is the type of issue, for the reasons Justice Meade has indicated, that to raise it, you need to probe into the judge's thinking, so you would need findings on it. Having said that, mother's rights were not terminated because of conduct. As I put in my brief, substance misuse is not protected speech. Domestic violence is not protected speech. Unaddressed mental health concerns is not protected speech. Failure to cooperate in any way is not protected speech. Attacking the father while he's holding the child is not protected speech. Having a history of unstable housing is not protected speech. Having a chronic inability to control your unparental traits of character, which, although archaic language is the law of Massachusetts, is not protected speech. Threatening behavior is not protected speech. Inability to meet the child's special needs, which are pretty severe and will be ongoing throughout her life. That's not protected speech. Having an inability or an unwillingness to assume parental responsibility is not protected speech. Failing to visit since May of 2023 is not protected speech, and that included the 6 months leading up to trial. And having lost custody of her other 5 children is not protected speech. Although the findings in many ways do touch on speech, when you switch from findings of fact to conclusions of law, I believe it's clear that mother's rights were terminated because of her conduct, her behavior, and her shortcomings, not because of her protected speech. And frankly, much of the speech that's challenged in mother's argument is actually father's speech, and mother has no basis for even challenging the findings regarding father. Father didn't file a notice of appeal, and the case law is clear. You don't get to raise arguments on his behalf. So I think that's pretty much it, unless there are additional questions.
Seeing
rest
none.
on the brief and ask again that you affirm the judgment.
Thank you. Thank you all.
Thank you.
Our last case is 24P1141, Stanley Webb versus George LEONTIRE. Mr. Trundy.
Thank you, Your Honor. Little dicey. Good morning. Good afternoon, and may it please the court. Attorney Christopher Trundy representing the plaintiff's appellants in this matter. I'm largely going to rest on my brief here. There's just a couple of highlights I would like to point out. If there are any questions that the panel has for me, I'm more than happy to take those first.
What happened to the criminal prosecution?
That was resolved a month or so later. Both individuals received non-custodial resolutions. I don't know the exact details. I did not handle those. It may be that I think a whole number of charges had been leveled over a number of years, and most of them were dismissed, and there was some small part of each case as to each defendant that survived by agreement. On that point, defense counsel at trial made a big deal about the fact that this case was pushed forward while they were waiting for, that they should have waited until after a criminal charge. This matter took place, this attorney-client relationship, such as it was, goes back to 2017, after a number of search warrants were issued against various vendors who had Newtel gaming machines, according to the AG's office, and they saw them as, there was an argument about that. But the actual indictments or criminal charges did not issue for more than a year after the termination of Mr. LEONTIRE's representation. And then, of course, we have a number of years, including the pandemic. And in the meantime, the record shows that particularly Stanley Webb, who is ultimately the named represented party on the contract, had been looking for an accounting as early as a few weeks after he deposited substantial funds with Mr. Leontire. So he was certainly on notice to bring his quantum merit accounting claim in a timely fashion, which he did. And so the whole issue of how long it took the Attorney General to move to trial and all of that parallel process, I think, is a non-issue in this case. The case is basically a request by Stanley Webb and his daughter for an accounting of $139,000 that he was given and immediately put to his own use while engaging Jose Baez, a celebrity lawyer from Florida, under pretense that he would be involved in this case and that they would do some type of pre-trial investigation or pre-investigation, whatever that is. And Webb changed his mind, which he had a right to do, terminated the representation, requested an accounting. Leontire refused that accounting. Attorney Lynn Whitney made a formal letter request of Leontire under the rules to give an accounting of the value of his services. He refused. In response, Jose Baez, on behalf of Leontire, his partner in this matter, informed Lynn Whitney that this was a non-refundable agreement.
I don't understand why you say that was on behalf of Leontire, because Leontire sent his own response to the 93A letter.
No. To the demand, there was a letter, the record shows that there was a letter sent by Lynn Whitney to Leontire asking for an accounting. And that was shortly after the termination of the representation. Leontire testified that he did not respond, but that Jose Baez did respond to the letter. The letter was shared with Jose Baez, and Jose Baez's letter is admitted in the evidence, and his response was, this is a non-refundable $250,000 retainer agreement, and if you come after us, we are suing for the balance, the difference between $139,000 and $250,000. In any event, the action that was brought was a completely proper action by clients to get an accounting. They were entitled to know what the quantum merit value of the services coming from Leontire for this $139,000 was. At trial, and the burden was on the lawyer. Leontire countersued and said he was entitled to a total of $200,000. The burden is on the lawyer here. At trial, I called Leontire case in chief and established through a number of admissions that he did not follow ethical rules, that he did not provide an accounting, that he never provided an accounting to them. He later provided a constructed billing record based on some telephone records, which he gave to the BBO, and the BBO passed those on to Mr. Webb directly. And that came in as evidence that he made up some 4 or 5 months after the fact. He never provided any work product, anything. There was testimony that one of his associates, Ron Sullivan, had contacted the Attorney General's office and had some communication. Sullivan testified that he had done that and he was not looking to get paid for it. So what we had was this case really based on Leontire's own duty to come forward and articulate what he did, why he was entitled to retain the money. Ultimately, the judge, in his findings, said that Leontire was entitled to the $139,000, but not entitled to the difference between $139,000 and $200,000. So effectively saying neither party wins. I would suggest to you that that is insufficient in terms of findings because we don't know what burden of proof he was using. It appears he was basically saying neither side proved a claim against the other. But that's not the law. The law is that Leontire must prove his quantum merit value of services. And I would suggest an examination of the record shows that it was woefully insufficient. But the main point on appeal is that at the point at which we moved through Mr. Leontire's testimony, I called Jacqueline Webb to talk about the relationship between Leontire, the chronology. There was some issue about...
The court finds that Leontire has shown the value of the services rendered for Webb's meets and potentially exceeds the $139,000. So what don't we know about the burden there? He said Leontire showed it. What's missing?
Well, that's I would say that's just simply a conclusory statement, and it overlooks a huge amount of evidence in the record
But you told
that
me the
Leontire
judge,
could
you
not
told me the
articulate.
judge applied the wrong standard.
No, I'm saying the judge's finding on that point is contrary to the weight of the evidence and is erroneous in that Leontire simply came forward and said, I questioned him at length at this. He couldn't tell me anything that he did on a given day. He basically said that every day, from the time he gets this $139,000, he was working on this case on an hourly basis at $600 an hour, a number he had never, that we were not allowed to contest because the two plaintiffs were essentially deprived from the ability to testify based on the judge's ruling that they had to incriminate themselves or open themselves up to self-incrimination. But he claimed that at some point he told them $600 was his hourly rate. That was also inconsistent with his claim that he was disabused of by the BBO, that he had a right to keep this money as a non-refundable fee.
But the judge is the finder of the fact here, right? And the judge finds upon examination of all the evidence that Leontire's accounting appears genuine, reflects a reasonable rate for the value of the services conferred on the clients, right? So what are we supposed to do with that? We're supposed to sort of say, no, the judge got it wrong, found the wrong facts, and find our own facts?
I think the problem is that he does not articulate what the quantum merit value is. To simply say, okay, he gets to keep the $139,000, I think is inadequate.
What did the judge need to do in your view?
Say what he did that equal quantum merit being the value of the services to the client. He doesn't say what those value of the services are. We don't even know what Attorney Leontire did. Leontire couldn't tell us on any given day when he charged thousands of dollars. He was charging $5,000, $6,000, $7,000 a day. What he did for that money.
So are you saying that the judge had to say exactly what the value of the services was, or that he had to recount exactly what Leontire did every day?
No, I'm not saying that. I am saying the judge would have to articulate what the value of those services were in terms of the benefit conferred on these individuals for $139,000.
He says the value of the services exceeds $139,705.26.
Well, yeah, but it doesn't tell us what the value, what those services were.
Well, he says on page 11 of the decision, Leontire's work focused on reviewing gaming legislation before and after Stanley's prior criminal case, required analysis of voluminous financial, tax, business, and real estate records. He was in near constant contact with the Webbs, had to work with the enormous amount of materials they presented him during the representation. So there is reference to Leontire's testimony and findings about what he did to sort of justify the amount of billing that the judge found. What do you want us to do? You want us to say, judge just got it wrong?
Well, I bring this up as it's secondary to my main point, okay? Because I think that there are substantial problems with the judge's decision, particularly overlooking the explicit violations of Leontire's obligation as an attorney to a client, which are established 93A violations. What I would say is
Could you walk me through the 93A violations? I had a little trouble following your brief on that.
Okay, well, I'm sorry about that. It's not the first time I've heard that. But, so the rule requires that when a client discharges an attorney, they're entitled to an accounting of the money that they paid, period. They're entitled to a refund of what was not earned, and they're entitled to a prompt accounting of what the attorney did. He did not do that. He failed to do that. And that really is that's number one. Number two, he treated the money deposited as a non-refundable flat fee that he could keep and never account for. And that was his position up until the time, 4 or 5 months later, that the BBO told him that was unlawful. Those are at least two. There are a few others in the brief, but there are...
Please give me them all. I got those too, but I mean, I was having trouble following. The only other thing I got was that for billing between August 10th and the 20th.
Well, I'm not... I would say this, that there were some issues of... well, there are issues involving the fee agreement itself, which he did not provide a copy to the clients, refused to give them a copy when they asked for it, and the testimony that was stricken supported the inference that the fee agreement that he ultimately produced was not the actual fee agreement that he had Mr. Webb sign. And that was the significance of the main point here, which is that by allowing the defense counsel to force the exercise of the Fifth Amendment privilege, which the judge said, if anybody exercises the privilege, I will strike their testimony in full. That created a huge incentive for the attorney to do that. He did strike that was improper. He said at one point, yes, we shouldn't do that, but then allowed it on the other hand. So he recognized that it was not correct, but then allowed it to happen.
Well, but it looked like you invoked the Fifth on all further questioning, no matter what it was. Doesn't the judge have to strike the testimony at that point? It'd be one thing if it was just particular questions.
Well, there were no further questions that were not intended to induce, to fill in the chain of evidence in the underlying criminal charge.
How do we know there weren't any questions after you said, I would state for the record at this point she would invoke her privilege as to any further questioning? How do we know what the further questioning would have been?
We don't. But I believe that was my obligation in consultation with their criminal defense lawyers, that once she invoked her privilege, or once Stanley, who was forced to invoke his privilege by being called by the defense, because I did not call him after I was told that this would be allowed, that at that point, once you invoke it, you can't pick and choose the questions you answer. That is my understanding, and it was clear from virtually all of the questions. I'm sorry, I'm out of time.
Thank you.
Thank you.
Mr. Hagstrom.
Yes, good afternoon, Your Honor. Good afternoon, everyone. My name is Kurt Hagstrom on behalf of the defendant appellee, George Leontire, and we're urging the court today affirm the verdict that the Bristol County Superior Court reached, and in particular to uphold the evidentiary rulings that were made over the course of the bench trial. Your Honor, if I could just shift focus to the billing record that was ultimately introduced by Attorney Leontire, I would just say that while it wasn't produced contemporaneously, the BBO did evaluate it, as did the judge. Both parties reached the conclusion that it was produced in good faith. I would note that the judge had the opportunity to evaluate Attorney Leontire's.
How do we know the BBO determined it was produced in good faith? They just seem to say, we don't do billing disputes.
The BBO didn't raise further questions. No further investigative steps were taken. So I guess I would anticipate, had there been questions, or had the BBO found Attorney Leontire's conduct with regard to the billing record to be worthy of further examination, further inspection, that they wouldn't have ceased the investigation at that point. So that'd be my response to that. But in regard to the billing records that were delivered to opposing counsel, that were provided to the WEBs, that were introduced at trial, the trial judge did ultimately conclude those records were credible, that they were produced in good faith, and that they do account for the time that Attorney Leontire spent on this case. I would suggest there's a great deal of testimony in the trial, as put forward by Attorney Leontire, talking about all the work that went on and talking about some of the complexity of this case. I would also note how short the time frame we're talking about here actually is. This is a roughly 2-month span in which numerous warrants are issued, multiple regulatory bodies are asking questions about the WEBs, state police are asking questions, local law enforcement is asking questions. They don't necessarily know what the final indictment is going to look like at that point. And so they're trying to approach this matter from an abundance of caution, trying to protect all rights for their clients as they are involved, as they appear to be, necessary. Now,
Can I ask about whether or not the WEBs had a fair opportunity to kind of present their side of this dispute, right? And this was essentially a dispute about whether or not an attorney deserved a certain amount of money for his services, right? And yet, Mr. Leontire's trial counsel, Mr. Reddington, seemed determined to force the plaintiffs to testify about matters at the heart of the criminal investigation, sort of saying, did you structure transactions, right? He said to the judge, they're skimming money, right? It seemed to go way beyond what I would view as sort of proper questioning about a fee dispute and getting to the heart of their criminal liability in a way that seemed obviously likely to lead to the result of them invoking their Fifth Amendment rights. So the judge seemed to do his best to kind of police this, but the whole line of questioning strikes me as very problematic, and I just wonder what your thoughts are about that.
yes, Your Honor. So I would simply state that Attorney Leontire is entitled, well, the challenge here is being made that extraneous work is being conducted, that the work being done is not necessary, that it doesn't reflect what is going on, legally speaking, in regard to this matter. The legal services, they're not necessary. That's what the WEBs are alleging. And that seems to go directly to the scope of what attorney-client representation in this matter actually is.
And so you're allowed to ask your former client, did you structure transactions? As opposed to, were you being investigated for this? Or what was the scope of the investigation? The sort of questions directly going to their alleged criminal conduct. That seems to be a far different thing from sort of saying, was the work that I did related to their potential liability? Do you see what I'm asking? It seems very much focused on, did you do this, did you do that, and accusations that they were skimming or engaging in financial misconduct.
Yeah, and they were free to respond to those questions with regard to their conduct as well. As far as questions being designed to elicit Fifth Amendment privilege, no one forced anyone to invoke a Fifth Amendment privilege. The WEBs did so in this case apparently strategically, apparently because they didn't want to respond to those questions. I mean, a simple answer might have been no, or we weren't involved in anything like that.
But was the question itself proper to ask somebody, are you structuring transactions? Is that a proper question to ask in a dispute about the amount of fees that attorneys
I would say it is proper insofar as you're trying to argue that, there was no need to look into the possibility of structuring transactions. So there was no need to look into any of this material. They're trying to argue on the one hand that the legal work that was done, it wasn't essential, it wasn't necessary, it's not a reflection, or it's being advanced not in good faith to represent our interests. On the other hand, they won't give a full picture of why this legal work might have been necessary and what interests were being, perhaps the question was inelegant, perhaps it could have been phrased differently.
Well, one question was deposits under $10,000 to evade the reporting of cash transactions over $10,000. You did that on a number of occasions, did you not? Right? That doesn't seem to be like, that seems very unrelated, that seems marginally related at best to the question of the reasonableness of the fees charged, and it seems much more of punishing these former clients for challenging, for bringing this action.
But as to the reasonableness of fees charged, I mean, the line of that questioning, it would implicate a tax investigation, it would implicate many different matters. And these are matters that the WEBs apparently are denying that Attorney Leontire was hired to conduct on their behalf. And so on the one hand, you're asking Attorney Leontire to account for himself and the work that was done on this case and why he operated for the issues that were on the table. I grant you that is a very aggressive line of questioning, but I do think the subject matter firmly has to be a part of any proceeding to fairly address what work Attorney Leontire did do in this matter. And with regard to, well, I've talked a little bit about the billing issue at this point, and that the trial judge, was the one in the position to evaluate Attorney Leontire. evaluate the facts, made a determination that Attorney Leontire's testimony was credible, that the record that was submitted was indicative of the work that had been done in this case. I would also go toward the relevance of the scope of Attorney Leontire's representation. This is what we were alluding to a moment ago. Attorney Leontire this is a very complicated investigation. There's a lot of things happening very, very quickly. Ideally, Attorney Leontire would have kept contemporaneous business records, but the situation they were in was such that he dropped everything, worked exclusively on this case, and only after the fact produced records, and did so to the best of his recollection, after reviewing relevant emails, after reviewing all the phone calls that were made, other correspondence he had, in an attempt to reproduce hour for hour what work had been done on this case. And finally, in regard to the decision to strike the plaintiff's testimony here, the fact is the judge did caution the plaintiff repeatedly about what the consequence of invoking the Fifth Amendment privilege on all further questions would be, and that the judge would be inclined to strike her testimony if that was the decision the plaintiff made. And the plaintiff made that decision anyway, and the plaintiff made that decision knowingly, and the judge followed through. There is no abuse of discretion here insofar as, is it reasonable to consider the scope of Attorney Leontire's representation? It certainly would seem so. Perhaps another judge would have ruled differently, but I think that firmly a question as to the scope of services being provided is a reasonable matter of inquiry. Is it reasonable for the judge to strike the testimony of a witness that won't answer questions on cross-examination? That also seems to be reasonable and well within a matter of judicial discretion. And while I appreciate that my brother thinks that it should have been a narrow line of questioning or that the judge might have ruled differently, those are matters left to the discretion of the trial court. And it's in the sound discretion of the trial court that those matters are often resolved. Unless you have further questions, I will rest on my brief at this time.
Seeing none, thank you. Thank you both. We'll take it under advisement. That'll come to a close of the session. I'd like to thank my panel, our law clerks, the court officers, the clerk's office, and our excellent timekeeper, and we will stand in recess.
Very nice to meet you. We spoke on the phone when I was looking for extensions.